Hello everyone, my name is Zara Pabani. I'm a partner here at Irwin Mitchell and I'm in the hot seat today for this live webinar in which we are literally going to travel around the globe together. Today we will be looking at family law in 4 jurisdictions: the UK, the US, Singapore and Australia. We've handpicked a panel of international family lawyers to talk about family law in these jurisdictions. As well as we're also going to ask them to give some insight into their own personal journeys as international family lawyers. Now, on our panel today, we have from the UK, Ros Beaver, my fellow partner and head of family law nationally for Irwin Mitchell, Larry Ginsberg, partner at Harris Ginsberg, based in the US. And thank you so much, Larry. You're the one joining us at the most unsociable hour. We also have Gloria James, head lawyer at GLC Law, based in Singapore. Thank you, Gloria, because this was very much your idea. And thank you for bringing it to us so that we could put it together. And of course, last but by no means least, from down under, Will Jones, partner at Sayer Jones, based in Melbourne. Now, we'll be looking at similarities and ways in which we can learn from our international colleagues, and also how we all deal with international clients and multiple jurisdictions. We'll take questions at the end, but you can put your questions in the chat as we go along. If you can, add your name and email address to the question so that if we don't get to it, we can always contact you thereafter. We've also put in the chat our feedback questionnaire. You'll see that pop up in the chat throughout. Please do try and fill that in and return it so we can see what else you'd like us to talk about and if there are certain areas of family law that you'd like us to do a deep dive into. So let's make a start this today. Ros, let me start with you. Now, it's still often said that the UK is the divorce capital of the world for women, and in particular in London. Is this still the case? And if so, why? What makes it a more attractive jurisdiction, especially for wives?
Thanks, Sarah. Well, that's a really sort of a question that's often debated quite widely. Perhaps the easiest way to say it is because we have a discretionary, inquisitorial system, and much of our law relating to financial remedies is judge-led, with statute law being a broad palette and the judge then providing the details between the lines, if you like. So we are privileged to be, in my opinion, in a jurisdiction with so much flexibility. It's the discretion, and it offers a broad basis upon which particularly the weaker party has a fair crack of the whip, if you like. I hope that answers the question, Zara.
Thank you, Ros. And that's so helpful because at the end of the day, we're very much discretion based in the UK. And it's interesting. Is perception always reality? But I think the key is as well, making sure you've got your representation right to make sure that you are with an international lawyer who knows what they're doing. Larry, coming to you over in the US. Again, what we hear so often from the US is that it's incredibly litigious. Now, I know that there can be massive variations from state to state, but overall, that's what we understand. Tell me, is this true? And what focus do you have on alternative ways of dealing with cases, for example, mediation? Tell me where you're coming from, Larry.
Thank you. Good morning, everyone from the beautiful Midwest of the US at about 2 a.m. So I appreciate everyone's focus and attention on the panel. Thank you, Zara, for including me on this. And I so much enjoy spending time with my colleagues and talking about these issues. I'm always fascinated to think about and hear about the perception that other jurisdictions have nationally and internationally on how things are handled in the States, and certainly in California. And it's certainly curious, not just within the United States, but also within specific and certain states about how things are handled versus, litigation, mediation, perspective of resolution, and those kinds of things. For example, in California, I'm based in Los Angeles, there's a very different practice model and perspective if you're practicing in Southern California versus Northern California, like in San Francisco or points northward from there. We tend to be viewed as more litigious in Southern California than in Northern. We're all very focused on mediation in my perspective, but there is kind of a default perhaps in Southern California or certain practices to litigation. Interesting perspective resulting from the pandemic and from COVID. I have a good friend, colleague, judicial officer who would tell anyone who would listen that perhaps it's time to make deals that might be less brilliant for your client rather than litigate, because the litigation process became so belabored and lengthy. And it still is belabored and lengthy. So most of us who I think are involved in the more creative model of family case resolution are focused on mediation. We have something here as well that we refer to as capital C collaborative law, which is a model which is defined within the state bar. It's not codified in the statutes, but it involves written agreements at the beginning of any case where the parties agree that they've got collaborative lawyers. They'll bring in collaborative experts, therapists, mental health professionals, forensic accountants, etc. And they agree that they will focus on resolving the issues informally, and to the extent that they do not, none of the professionals who've been involved can be used. So it's kind of a velvet glove, if you will, to keep people focused on mediation and out of court. I happen to be a firm believer, notwithstanding having been raised in the litigation world in family law, with my former partners, Sorrell Trope and Trope. I happen to believe that the litigation model is wrong for family law, in particular regarding custody issues. And we work very, very hard, particularly with higher profile cases, celebrity cases, larger estate cases, to keep them out of the public domain. In California, everything in divorce is public. Anyone has access to all the files, all the information, anything filed, not parentage or paternity cases, but divorce cases. So while I'm not oblivious to the need for litigation in cases involving, for example, misappropriation, violation of fiduciary obligations, etc., we still do remain very focused both in California and around the country, because I do a lot of work nationally in various jurisdictions, with coming up with creative ways to keep things out of court. I'm a fan of saying that, the law only provides a certain number of arrows in one's quiver. The law does not provide many alternatives with regard to how these issues that we face every day can be resolved. And if we as creative professionals can come up with better ideas for resolution, that should always be the alternative. I do think, just one more comment, I do think much of this is also generational. I'm basically a dinosaur, having done this for as long as I have. But I do think a lot of younger lawyers are much more open to the concept and the context of mediation and collaborative and other dispute resolution options than defaulting to the old-fashioned litigation model.
Larry, thank you for that so much. I would not call you a dinosaur or old-fashioned, my friend, but it's interesting what you say, because isn't it the fact that it's about options? Clients want and need options. Some people want their day in court, whether that be the right thing or the wrong thing. But I like your creative scenario that you talk about, which is, I think, what we're all trying to explore, where the pandemic forced people to look at different ways, particularly in the UK, where the court really struggled during the pandemic. Everybody needed to look at a different way to support our clients and their needs, particularly on an international basis. So thank you for those comments, so helpful. Gloria, coming to you, it'd be really good to understand the situation where you come from in Singapore. Where does Singapore sit in terms of litigation versus alternative dispute resolution options? And what do you favour?
Okay. Personally, I favor mediation. So perhaps I could explain to you the process in Singapore. The good thing is Singapore is a very small country, so it's different from the US, what Larry has shared, that, Northern California and Southern California and all, you have different practices and all that. But Singapore, the current practice is the courts take the approach of what is now known as therapeutic justice. So if you were to log into the family court website, the first thing you will see is therapeutic justice. Basically, it means that the court wants to move away from litigations, encouraging all parties, including lawyers, judges, and even you have counselors and therapists all involved in helping the client. So it's basically trying to resolve the root of the problem, so getting rid of the conflict that parties would face, and helping them to look at the big picture, how you can move on with your life, try to have an amicable resolution. So all of us are viewed as therapeutic justice agents for the families. And all the different ADR options would include not only mediation, but we also have neutral family evaluation. We don't have arbitration, but perhaps that's something in the works. And we are encouraged, we do follow the model Larry has just explained about collaborative family practice. I would say that it's exactly 10 years old since we have been trained in this collaborative family area. So in Singapore, once a divorce writ is filed, parties would have to attend mandatory mediation and counseling. So litigation is basically the last resort. And with a high success rate in mediation, maybe close to about 60 to 70. I even heard maybe up to 80% of cases being resolved at mediation stage. So it basically means only about your leftover 20% is going for litigation. So back to what you asked me. So what do I prefer? Obviously, mediation.
Mediation.
Yeah.
Look, Gloria, that's really interesting. I mean, that's a high statistic. I mean, I think you see a lot of lawyers really favouring ADR and a lot of clients, but that's a really high and an impressive statistic, if I may say so, about settlement at mediation. And this concept of therapeutic justice, that is really interesting and not something I was aware of. So, but what I would say is, particularly in our jurisdiction, and I'm sure a lot of jurisdictions, favouring and encouraging clients to look at any form of therapy, coaching, counselling, to think about how they're going to move on with their lives. I mean, I think with international clients and certain types of clients, you spend so much time with them, so much of their life, you become so entwined with them. And at the end of a case, it's quite hard for them to move on without you almost. So passing them to another professional who can take them on their next journey is so important. And we find that a lot in the UK. So Will, coming to you, let me bring you in now. When we look at Australia, we often liken it to how we do things in the UK. I think there are many similarities in the way in which we work. What can you talk to us about what the culture is of family law in Australia? Where are you guys headed with mediation and other options? And what does a future of family law in Australia look like?
Zara, sincere thanks. And firstly, can I just say how much of an honour and privilege it is to participate in this paper with such esteemed company. Zara, 2025 will mark the 50th anniversary of our current legislation, the Family Law Act, which is a federal piece of legislation encompassing the entire country. It was somewhat revolutionary at the time, given it was the first piece of legislation across the common law that really implemented no-fault divorce. And what that did at that time is effectively allow parties to focus on the practicalities, right, of both the division of assets and in turn the custody of children, rather than getting too bedded down in the proving of fact and jurisdictional issues on the end of the relationship. That's not to say it hasn't been without fault. It has been a piece of legislation that's been revisited upon, rules rewritten and the like, with some regularity, most recently in 2021, which I'll come to in a second. But in essence, what it did do is it allowed people to focus just on moving forward rather than focusing on proving too much as to what had occurred. And that has then allowed practitioners over that period to evolve in their own strategy and planning and advice. Allows us just to look forward pretty much entirely and only really worry about the facts of the case in terms of the facts of the marriage that go to the very discrete issues as to the division of assets or what's to take place when determining a custody dispute. There is, however, a jurisdictional anomaly in the legislation. It does not mandate mediation for financial cases. In fact, the court does not have the power to order mediation for financial cases. It is very much the court's expectation that parties effectively elect or consent by agreement to participate in a mediation, and that can be made by way of consent order. But you cannot get a judge to order parties off to mediation. 9 times out of 10, parties under sensible advice will still elect to do that, will enter into an order committing themselves to do that, to make sure that the resolution pathway continues with some proper purpose. But you cannot have the court order it upon parties for financial cases. I'll come to the parenting aspect shortly. That, however, has evolved very slightly when there was some reform at the back end of 2021. And what that reform did is it empowered the mediator to effectively be the arbiter of whether both parties were attending the mediation in good faith. And it mandates the mediator to execute a certificate to say that both parties, neither parties or one party or the other, did not participate in the mediation in good faith. And that certificate is handed to the judge that has the currency of the proceedings. So whilst the judge will never really know what took place at mediation, if the wrong box for a party is ticked on the mediation certificate, it will go against that party's credit when the case is tried. On a parenting case, however, there is a very more stringent prescriptive reform in place for mediation, and that's this. A party is unable to file an application with the family court unless they can present to the registry when they go to do so a certificate that proves that they've been to alternative dispute resolution that has been convened by a certified alternative dispute resolution practitioner, and that they've gone along to that and it has not been successful. The resolution of the custody arrangements has not been successful. And only with that certificate will they get into the door of the family court. As always, there are exceptions to that in matters of urgency, in matters where there has been family violence issues and the like. The party will then go on affidavit to explain why it is that they don't have that certificate attached to their application. Once the application then gets filed, the matter proceeds down the usual course before a judge. So there is a clear distinction there between how financial cases are prosecuted via the mediation realm, which is still technically by election of the parties, as opposed to the custodial cases, where you do need the certificate in the first instance before you get through the gate.
I want to ask you another question while I'm with you. So mediation isn't mandatory. Do you see it becoming mandatory? Is that going to change?
It's an interesting question, because in our experience, there is very rarely a financial case that will not go to a very well pre-prepared mediation, right? As I said, the court's expectation is that you do it, right? There is a requirement now for the mediator to present the certificate. And if you essentially elected to not volunteer yourselves into that process, now it genuinely does go to an issue of credit. Whether it ultimately does get mandated is perhaps a story for another day. But in some respects, Zara, the question that you ask is almost an academic one, because that train of proceedings being issued, everybody going off to mediate usually with a relatively senior member of the family law bar to determine an outcome at that juncture is such a well-trodden path these days that it may as well be mandated. But I just thought, for the purposes of your audience, when we're discussing these beautiful nuances between our jurisdictions, that it is not there in our system for financial cases only. I reiterate.
Larry, I'm sorry, Will, that's fantastic. Really interesting and really informative. Thank you so much. Ros, coming to you, you may want to comment on some of the things you've heard, but take it in a slightly different direction. For you, I was going to ask, how do you address the situation when a UK client is getting married but has assets in multiple jurisdictions? What is your focus, and when and how do you liaise with your international counterparts? Is the best way to protect your money in the UK simply not to get married?
Well, thanks, Zara. I mean, just listening to Will and to Gloria, what occurs to me is that there are so many similarities, but it's the nuances that lead and give rise to us needing to make these friendships and alliances so that we understand and we're not being sort of dragged down a path where we're imputing our own knowledge when we take on a case, which is probably relevant to the question you've just asked me. Starting with the end of the question, I'd probably say it probably is safer not to just not get married, to be perfectly honest. But that's not to say there aren't safeguards you can put in place. So for me, the first thing I'd do is I'd pick up the phone to somebody like Gloria, like Larry, like Will, if they were the relevant jurisdictions, because knowledge means that you can have a really broad-based understanding of the case. The temptation otherwise to lapse into imputing the English system onto the case. So the first thing, that's the very first thing I'd do. I'd focus on getting a very clear understanding of what the position is in those respective jurisdictions, and actually approaching it really strategically, so that we're looking at this from an absolute bespoke, client-centered perspective. And that's so important, because these nuances, they bring in another dimension. So it might be, I mean, I was really fascinated to hear what Will was just saying about mediation, because it's more or less the same here, you know, and that's, and another point, I guess, when we're looking at a prenup or a pre-cohabitation discussion, or it might even be that you were looking at something when you were, I mean, recently I've been looking at something where I'm planning for, sadly, a terminal illness, and we're planning for what's going to happen post-death. We've, not that it's an Inheritance Act case, we've been doing it in the context of what we're going to do with the children, etc. In those cases, it's a brilliant forum to use something like mediation if you can't reach an agreement, or just an early neutral sort of evaluation of the situation, and having friends like we've got is brilliant for those purposes. So the first thing I do is focus on understanding the position in the jurisdictions. And the second thing I'd look at, because I think it's all important, is enforcement, because there's no point having an agreement. We can all have an agreement, we can all have an order, but if you can't enforce it in the respective jurisdictions, you're at Houston, there's a problem. So I hope that answers the question. And no, in answer to the last part of it, I've already said it, but probably the easiest thing is simply not to get married.
Thank you, Roz. And we get asked so many times these days, don't we, about wealth protection. You know, it's a really key focus for us. And as you say, it's about it's client-centric. It's about putting the client at the heart of it and looking beyond that then and reaching out to our colleagues around the world. Thank you for that. Larry, in terms of your practice, how much time do you actually spend dealing with international prenups? Does it form a considerable part of your caseload? And also, do you see them regularly contested, or given that, as I understand it, they form part of legislation in many of the states in the US? So isn't it just a formality of executing them as opposed to them being challenged? I'm really interested to hear that from you, Larry.
A couple of comments, if I may. First, with regard to a couple of comments been made, and this is why I love these panels, because I learned so much and I listen, and I do appreciate so many of the similarities. And to Will's comment, the nuances of the variety of kind of considerations. First of all, I just want to shout out to Gloria for the term therapeutic justice agents. I actually wrote it down. I'm going to have T-shirts made for all of us, and we're just going to be called therapeutic justice agents. I think it's a beautiful concept in the context of what we do. And also just picking up again, before I get to the prenup issue and the question about Will's comment about the mediation issues, in California and in many jurisdictions in the states, we don't have other than kind of uncertain layers of custody litigation, et cetera. We don't really have mandated mediation, but we have a lot of tools built into the statutory scheme that practitioners can avail themselves of, what we call case management conferences. You know, judges are desperate to clear their dockets. They're desperate to move these cases to other avenues for resolution. And so we provide statutorily a lot of tools to judges and to practitioners to say, this is a particularly difficult or complex case. We have special master possibilities. We have evidence code 732 that talks about, you know, appointing experts for the trial to guide the court. Anyway, just a kind of a digression on those kinds of things that are available in California and elsewhere in the states. With regard to prenups, prenuptial agreements and the international component, I guess my friendly amendment to the question, rather than just calling them the international prenups, would be the kind of these multi-jurisdictional issues in prenuptial agreements that Roz was speaking of. And I join wholeheartedly with Roz in the comment about the first thing I always do is get on the phone with you all or other colleagues around the world to say, this is what's happening, this is what we're looking at. I do have the comment quite often with clients. My initial discussion has to go to the point of what the world looks like in the context of their relationship if they do not have a prenuptial agreement. I often stop short of saying better to not get married because that's their decision, although to Ross's point, that is the safest way to go, certainly financially. But we always try to figure out exactly what the law says in a variety of jurisdictions without a prenuptial agreement, so then we can determine together, hopefully, what we can accomplish in the prenuptial agreement, in assuaging fears, in addressing familial multi-generational wealth issues, to Roz's point as well about what happens in the context of death and et cetera, looking at trust and estates and all those kinds of things. But we have in the states something called the Uniform Premarital Agreement Act, UPAA, which has been adopted in all 50 jurisdictions, which on the one hand provides great guidance with regard to what we must look at in terms of what we all look at in a variety of these agreements about disclosures, about ensuring that both parties are adequately represented. There's an unusual permutation in the UPAA code as codified in California that says that while both parties do not necessarily have to have lawyers, and certainly I don't know any prudent lawyers who would do a prenuptial agreement, international or otherwise, without good lawyers on both sides, often several lawyers from several jurisdictions to make sure you're crossing T's and dotting I's. But under California law, you can have a prenuptial agreement that's enforceable with one lawyer, but the obligation then falls to the lawyer to explain to the unrepresented party all of his or her rights. And if nobody understands or appreciates the inherent conflict in that, we should have a different discussion. So I don't know any good practitioner internationally or otherwise who would have a prenuptial agreement without lawyers on both sides. It is not, there are certain jurisdictions with which I've been involved, and I'm going to say Canada and South Africa because I think those are two of them that have the premarital check the box, choose a regime prenuptial agreement. Marital regime, separate regime, and we've litigated those from South Africa and Canada in Southern California. I apologize if those jurisdictions have changed that process or if I'm misrepresenting what that process used to be, but it is not and never has been in California a check the box kind of process. There is nothing in California, certainly and in the states, that is an ironclad prenuptial agreement. And the most open issue with regard to all jurisdictions, both on an international and local scale, is that of spousal support and what one can do in a prenuptial agreement with regard to legislating, if you will, spousal support on the back end of a marriage. In California, you can pretty much do anything, but we have something called the second look provision. I don't want to get too far in the weeds, but where a court, upon the challenge of a prenup, can look and see if the support limitations are unconscionable, which of course is not capable of being defined. It is never a certainty in the prenuptial world, in my perspective, as to the enforceability. There is never something, as I mentioned, about a kind of a concrete, this is ironclad. But whenever we have multi-jurisdictional prenuptial agreements, which I really, really do enjoy working on because I find them fascinating. Again, my first thing is to call my colleagues around the world and to make sure that the prenuptial agreement, to make it as enforceable as possible, because lives are transient, people have homes and investments and raise their children in different jurisdictions as the marriage goes on. None of us have that crystal ball as to what unfolds. I want to make sure that if there are ties, financially or otherwise, to certain jurisdictions, that the agreements reflect that professionals in those jurisdictions have been consulted. That in fact, the intent is in a multi-jurisdictional enforcement clause, a choice of law clause, if you will, that it reflects that we've all been on the same page, we've all looked at the terms, and we've all agreed that no matter where this divorce happens, should it happen, or this separation, we agree that this will be enforceable in that jurisdiction. One more small comment, if I may, which is that, we like to make sure that we pull out the crystal ball to the extent we can. We also always acknowledge that these jurisdictions change laws as time goes on, as we do here. And we try to be very, very clear that the law and the understanding on which we're basing the agreement will hold no matter what happens in the future as the laws progress and change in multiple jurisdictions.
That's the point, isn't it? It's the crystal ball gazing, which is the frightening piece, because you have no idea what your clients are going to do long term. They might think they know what they're going to do, but that might change throughout the time. So it is a really complex area. And I think, as you say, Larry, we have to rely on the knowledge. Knowledge is power, the knowledge that we have and that we gain about other jurisdictions, but keeping up to date with that knowledge. And the only way to do that is to reach out, which I think is invaluable. Gloria, please do feel free to comment on anything that you've heard so far. But what I wanted to come to you about was wealth protection generally in Singapore and understanding how it works. I mean, the fact that you talk about your mediation success being so high, I'm really curious to know where wealth protection sits in that, and what are the key aspects that your international clients need to consider on marriage or indeed on cohabitation, and what is it that your practice focuses on in particular when it comes to wealth protection? Gloria, over to you.
I have to, perhaps let me share with you some numbers. I'm not sure if you're aware that Singapore is now the third in the world for the inflow of the number of ultra-high net worth individuals coming to Singapore. So we're going to deal with a lot of people with lots and lots of money. I do understand I think by 2026, there's going to be at least 6,000 ultra-high net worth individuals. So I guess that could explain why we keep having many phone calls, inquiries via emails and calls, asking us how do we protect the assets. So when such clients make an appointment with us, the first thing first, what we do is, exactly, touching on with what Ross and Larry has shared, is how do you ensure that your international client is well protected? So we always advise them the same thing, we put you to some of our contacts. You have to understand the difference, how the law applies in different jurisdictions. So basically in Singapore, when it comes to divorcing, the starting point is never 50-50. So that's what I always tell them. It is operating on the principle of what is just and equitable. So if you have a marriage, if you have a trailing spouse, example, you're married and coming to Singapore, it's a party that, both of you have been cohabiting, say maybe in the UK for 10 years, and then you come to Singapore and you get married for 3 years. Your length of marriage it's only counted as 3 years of marriage. It's not 10 plus 3. So then it's viewed as a relatively short marriage. So for a short marriage, what should your entitlement be? It's no longer viewed as 13 years of marriage. It's only 3 years of marriage. So these are some of the basic information. Is very important that you share with the clients. So the clients would then have an idea. Is it a must that I have to do a prenuptial agreement, or do I have to do a postnuptial agreement? And importantly, they would always ask you, is my agreement, will it be upheld in the court? So we have to tell them that, any agreements that is made in contemplation of divorce is all subject to the court's scrutiny. So where I'm coming from is, if a client comes to me and asks me, should I marry or not? I say, end of the day, the decision lies with you. Because if you're going to get divorced in Singapore, I wouldn't say your outcome is it could be a lot better than if you're divorcing in the UK or maybe in the US or even in Australia. So, you've got to watch what kind of clauses you want to put in the agreement, especially when it comes to which country is going to have the exclusive jurisdiction. So back to the point of, when it comes to protecting your assets, always go back to your colleagues in overseas and try to get as much opinion as possible before any informed decision is made.
Thank you, Gloria. I mean, it is, again, it's all about the strategy, isn't it? Putting in place a strategy, listening to the client, putting in place a strategic approach to best protect the client. Thank you for that. Will, tell us, what does wealth protection feature heavily in your jurisdiction? And if so, how do you approach it? Hannah, how often do you actually find yourself working on cross-border prenups? I'd be really interested to know that.
Zara, it very much does. Australia is about to embark on the biggest shift of wealth transition that it's had ever, as the baby boomers move on to the next life and leave all of their assets and the like to the next generations. It has caused for there to be much inquiry on the protection of really inheritances by the next generations as against separating spouses. So there is this discrete area of financial agreement work now that is looking pretty much specifically to just ring fence and protect an inheritance when it is received. The days of doing the carte blanche financial agreements of saying, this is all of mine, there is no claim on it, come rain, hail or shine, are pretty much behind us. These agreements these days are far more directed to protecting a specific asset, a specific interest, whether it be a legal interest in an asset or a beneficial interest in some trust property or the like, which not only makes the agreements far more certain, and I'm talking more so on a local level at the minute, right, but it also allows us to advise on their certainty with much more certainty. The Family Law Act provides a pretty prescriptive regime as to what is required in a financial agreement to make it valid, binding and enforceable. It again requires both parties to have legal advice on their rights and obligations on the agreement, and that advice also needs to outline very clearly the rights each party is foregoing by entering into the document. There are other conditions contained within the Act as to what makes the agreement valid, but I do pick up just another point of difference between what some of my colleagues have been saying today, is that there is a mirroring regime for de facto relationships that protect cohabitation relationships where a marriage is not envisaged or if it does not take place. So not marrying is not a cure here whatsoever. Gloria's fine office and our office have been participating in CPDs for nigh on 7 years now. And one of the great distinctions amongst many of the similarities is that the cohabitation relationship is very much an equitable relationship for the purposes of asset division and the like in Australia, and it is not protected in terms of that asset position from a non-marriage. So that regime for the financial agreements mirrors on de facto relationships as it does on marriages and prenuptial arrangements. With respect to the cross-border component, absolutely, we are often participating in the preparation of agreements that have some sort of cross-border or multi-jurisdictional component to them. However, for financial agreements, as opposed to court orders, which I'll just touch upon subsequent, right, for them to be enforceable in Australia, if Australia is the chosen jurisdiction for the agreement to be enforced upon, is it needs to fall within the categories and satisfy those conditions within the legislation. So both lawyers need to be Australian qualified, and they need to give the advice as against Australian law for that financial agreement to be valid, binding, and enforceable in this country. There is no provision for a foreign financial agreement to be given effect in Australia. That's different to having a court-made order in another jurisdiction where there is the ability to have those orders registered and implemented here. So that's the one distinction. So again, going back to what the other guys are saying, it's really about discussing with your colleagues, right, what is the most appropriate forum for a financial agreement to be given effect in, right? And that will turn on its facts. And there needs to be a really balanced discussion with, like-minded practitioners on what is going to be the best place and the best jurisdiction to have that agreement enforced, should it have to be enforced. I mean, we always have our clients sign these things hoping that you stick them in the filing cabinet for them never to see the light of day, but we know that that's not the reality, right? And they are the subject of some heated litigation, particularly when there is a cross-border component to it. So it's critical, apart from anything else, for self-preservation purposes, to make sure that we get the jurisdiction right when we're signing off on these deeds.
Will, that's incredible. I mean, you guys are ahead of the times in terms of the cohabitation law. I mean, we've been, striving to make a change in the UK for so long, and we are still not there. The protection for the cohabitees, I just think, is such an important point in law, and I hope we follow you at some point. Whether it'll be during my career, I have no idea. Ros, please do come in. You can comment on anything that anybody said, but I am going to change tack as well, really, because I'm really interested to hear about your journey in law and how you became one of those lawyers that deals with international clients. It doesn't happen to everybody. It's not everybody's niche. It's not everybody's bag. How did you get there?
Well, thanks, Zara. Just on the point that you've just made in relation to what Will was saying, I feel like we're almost in a horse and cart, galloping along-ish behind you, Will. Well, for me, I mean, nowadays we, as a team, we undertake a significant amount of work in London, and of course it's multicultural, lots of multinational presence there. So there are opportunities for our junior members of the team to do lots of international work, and we also work quite extensively to try and promote that, because it's obviously fascinating to learn more about international cases. For me, my journey into working as in the international sphere really was, I was one of those individuals who issued an application for what was then a residence order, and that became a Hague Convention case, because it was actually an unlawful abduction of a child, and so I unwittingly fell into it, but that was a baptism of fire, I have to say, and one which was rather embarrassing. So that was when I was a very junior solicitor. But interestingly, and we've got all these commonalities, but also international law, it's fascinating, it's fulfilling, it drives us. And just listening today to Will, to Gloria, to Larry, those similarities are the glue that stick us together as well and keep us together as a family law community. I don't know, I've not answered that in a very legal way, but more of a practical one.
No, that's great, Ros. You know, that's what, forget academics, it is all about practice, isn't it? It's not theory.
Yeah.
It's about how we speak to each other, how we deal with each other, how we deal with the client. So that's super helpful. Larry, I'm interested. How long have you been actually practicing, and what advice would you give to someone looking at focusing on this very niche area of international law?
Aren't there rules against asking people how long they've been practicing law?
Not between friends, Larry, not between friends.
It's about 2:40 in the morning here, so it feels like a lot longer than it felt an hour ago. I've been practicing since 1986, so I think that's, what is that, 33 years or so? No, 36 years or so, 37 years. Before I go to one issue about the international practice and how we've come to that, I just want to mention on this, I'm so fascinated by this conversation and Will's comments about de facto relationships and what Australia is doing. You know, if you guys are in a horse and buggy behind Australia, we're somewhere on a slow boat to ignorance in California. We are, you know, so. Perhaps the way to phrase it is the law is a relatively lazy master sometimes, because we prefer to have specific delineations in California. You're married or you're not. You're legally married or you're not. Cohabitation, as I mentioned, we had a bit of a discussion before we started this morning or this afternoon about cohabitation in different jurisdictions, and we have case law here that while it permits claims to be made for support and property rights from a cohabitant relationship, they are most often disfavored in the courts. So it's gonna be a long-winded way of saying it'll be a long time, I think, until California and many jurisdictions in the states come aboard with that cohabitant, really recognizing the cohabitant relationship in a legal way with regard to support and property rights. But back to the international, you know, I join Ross's comment on taking great comfort, and I know this is not the legal analysis, in the understanding and the relationships with our international colleagues to realize that while we have different practices, different procedures, different processes, we all deal with the same family issues on the journey that these families are on. And in particular, going back to the comment about therapeutic justice agents, you know, a role in the lives of our clients, which is, it's very comforting to have the conversations among international colleagues and realize we are facing most of the same challenges. How we handle them in different jurisdictions is fascinating and such an education. And I do think leads to changes in the law in multiple jurisdictions when you get the ideas presented. My short answer to people coming into this practice at a younger age or earlier phase of their careers is simply to say yes to everything. When you meet people in an international jurisdictional meeting, I'm a fellow of the International Academy of Family Lawyers. I have met just in casual meetings at those international meetings, a variety of just wonderful, talented experts from around the world in our area. And it's simply making that connection. And finally, I would say, while I think most of us come to this very, very interesting field for a variety of reasons from a variety of backgrounds, the ability to explore and understand the issues we all deal with internationally and take it beyond kind of the micro and go to the macro of what we all deal with is really what brings a fascinating element to this practice. There is never a dull moment in international practice, and I just support anyone who wants to explore that to reach out, talk to people who have those relationships and get involved, because it's a wonderful dynamic to experience.
Thank you so much for that, Larry. From that, I take say yes to everything. I mean, I think as a junior lawyer, expanding your experience and getting all the knowledge and all the opportunities you can is so important. And to any junior lawyers who are there today, I'm going to volunteer my panel. You know, I know that you guys will be happy if somebody reached out to you and wanted to have a chat with you to seek some experience and to seek some guidance, because what I take from all of you is very much that you're all about developing people and the future of family law. And the future is only strong if we support our bright young lawyers who are going to take it in a different direction and make it better. Gloria, coming to you. Law isn't an easy option. It's not an easy career. It's not a job, it's a vocation. And it can be quite demanding in terms of your own time when looking at the needs of international clients. How do you balance that? How do you do that in your own practice? What would you say to people listening about this?
Hi. Perhaps just let me, before I answer that, I'd just like to share some things that we've been doing when, prior to COVID. We used to attend conferences, international conferences, and that's where you get to meet many, lawyers, and you talk about international issues. We even had a lawyers exchange program with Saya Jones. So basically, we send someone down under and he sends someone to Singapore. So with that, we're hoping to start all this again. With this exchange of lawyers and attending conferences, it helps us to expand the international arena in the sense that our knowledge gets, we acquire more knowledge in this. So when it comes to serving international clients and, back to what you asked me, how do I find a balance? I would say it's that one must have the love and passion to love what you're doing. Yeah. And I've become accustomed to working in different time zones. I take it that, since COVID, we've been on Teams, we've been on Zoom. One day you could be dealing with clients or even lawyers in different time zones. You might be speaking to someone in the UK, someone in China, someone in India, and maybe someone in California, you never know. And it sort of brings, I don't know, I just like it. I just like the fact that, you're still able to do your international work, able to be of, to be of service to your clients. And there have been occasions, you ask yourself, should your clients bother you during the weekends or even on special occasions like Christmas and all that? But you can't really, shut your phone off, during this time, because you have situations when a client doesn't have access to the child or when a child goes missing. So what happens? The client comes to you, you being the first respondent to them, they look towards you to give them a solution. So even if coming back to the point about where do I find a balance, it's just that helping them, I think that's more important when you're doing international work. But if you have a client that simply messages you every time that client is, panic mode, is very anxious, for that, I have to politely say, are you willing to pay me more to respond to this? So that's what I do.
Yeah, no, Gloria, you've got to have a passion for it. I think what you said is so important. Having the passion is key to success, I think, in this area of law. You've got to really love it because you are on call 24/7. I think that's the reality of that, not just international family lawyers or family lawyers generally. It's what we choose to do. Will, coming to you. So what do you think are the key skills of one needs when looking at making a career out of dealing with international family law and international family clients? What's your view? And please do feel free to comment on any of the other things that have come up.
Thank you, Zara. It's in terms of that question, we need to appreciate that any matter that has any cross-border component to it is going to command some level of high technique in terms of the analysis and the advice that it is to be provided. Now, the starting point for that is to know your own forum, right? Know what the expanses are of the jurisdiction in which you are qualified, right? To then understand how that operates and how that functions in the global context. I think that when you look at it from that perspective, it then allows you to properly communicate, advise upon and engage with the deficiencies that may be in your jurisdiction, if there is a cross-border matter, where you can leverage off those that may be more appealing to a client that has a foothold in another jurisdiction. But you need to understand technically what the capabilities of your own jurisdiction are first. I know this is pretty boring to say, but it's actually probably the truth, right? That once you've got that bedded down, it then allows you to expand your mind and engage with your colleagues globally to see if there are better forums, if a legislative framework that is available in another jurisdiction that is a forum that may be available, right? It may be better to pursue it under that avenue, but you need to know your own forum to be able to give that advice. And so, as bland as it sounds, make sure that you know your own legislation. You know your own case law and the principles if they're applicable in the jurisdiction in which you're operating. And that will then allow you to provide advice locally. And when there is an international component, you'll be able to leverage off your understanding of how things would operate if it fell within your forum to then determine whether another forum is better or your client's going to benefit more from making applications in that other forum. And you do that through communicating with you guys and other like-minded people. But you've got to understand that it's always going to command a level of high technique in terms of the analysis and assessment of the instructions. And you need to pay it the respect that it's due, because often you're talking about some pretty high stake stuff. And to get it right's really important and really good, right? But if you get it wrong, right, it can be really damaging to your client's position, whether that's strategically, financially, and heaven help us in relation to parenting cases. So it's really important to know your own forum and the expanses of it.
Thank you, Will. I mean, it's technical strength, isn't it? You've got to have the technical strength. You can't play at this. Otherwise, you're going to be negligent and you're going to cause problems. You've got to have technical strength, and you can develop that and you can share it and you can grow it, but you've got to have the foundation there. Thank you for that. We're coming to the end of the panel questions, really. So, Rosa, the last question is to you, really. I really want to end with a few words from you. Erwin Mitchell, we're committed to delivering excellence, as are our friends here on this call, when it comes to international family law. And one of the ways we show this commitment here is by ensuring that we have very close alliances with international family lawyers, as is evidenced by this webinar. Can you tell us, for our audience, what the future looks like at Erwin Mitchell in terms of our international practice and where we're going?
Yeah, I mean, it is absolutely apparent from today that we're committed to forming alliances, but I think what Will said is absolutely bang on. Actually understanding and knowing the law and the technical position, whether that be from your own practice area as a family lawyer, but also there's not just the the international element of looking at it from a family law perspective, you might have another dimension that comes in as well. So we really are trying to build our capability internally so that we're working across different disciplines, and then finding teams in the other jurisdictions that work cross disciplines. Because as we all know, a family law case is not just about one aspect. It often touches many other areas. So what we're doing is we're really working internally and externally very hard to build teams of capability that can work across the disciplines, and then replicating it so that we've got those relationships externally. And the way in which we're doing it is we've got an international sector, if you like, across the firm, and then we have international desks devoted to particular countries and jurisdictions. And then of course we're members of IAFL, we attend 5Js, you know, we keep in touch with people. I mean, I met up with Gloria in Singapore. We don't even need to get on a plane anymore and increase our carbon footprint, because in this post-pandemic era, we can just join on Teams or Zoom. So we're really trying to build our technical capability and build relationships internally so that we've got that expertise, and externally. Big sales pitch here, Zara. Am I doing a good enough job for you?
Oh, no.
But yeah, that, I think it's all about relationships and an understanding of the law. We're lawyers, and the procedure and the nuances in other jurisdictions, we need to know them, but we need teams who know them, particularly when you come to that enforcement piece, I think.
Absolutely. I think the other thing for me really is the fact that we've got our international colleagues on here to do. I think the strength that what IM does is we appreciate there is excellence in family law in the UK, and we reach out to our UK colleagues as much as we reach out to our international colleagues, because we want to raise the profile of family law. We want to do what is right for our communities. Now, Ros, we're running out of time, but we're
strategic for our clients.
We did have a couple of questions, and I just wanted it if you could, in a really short way, if you can assist. One really complex question somebody put on there. They wanted to understand the concurrent habitual residence outside the EU as per the pre-B2R English case of ICAMI, which obviously was a particular case. Any quick comment on that you can give us?
I think probably I would say no, you can't have concurrent habitual residence. You can only have one habitual residence. However, if England and Wales continue to diverge from the EU approach, and there appears to be some divergence, for example, in Merino and Monroe approach, where English law now says you only need to be resident, not habitually resident, for the 12-month period to application for divorce. So provided you were habitually resident on the date of the application, whereas the European Court seems to say that habitual residence is required for the full period, then we may potentially see this argued. So I hope that
helps.
Answers the question.
That helps. And then somebody has asked, I have to say, I might have to leave this one. Somebody did ask about the recent, any kind of update on Hague Convention matters. I mean, I think that's a whole webinar in itself. Is there any comment you want to make on it quickly, Ros?
I think that they perhaps mean abduction.
Yes, I think they're probably coming from that angle.
The recent Hague Convention case. So it's a massive topic. I mean, there's lots of situations like the war in the Ukraine and the present additional challenges for the courts. There's been loads of movement, especially for women and children, but it's clear that there's not really one size fits all approach. And the court, it's looked at particular situations in each case, making return orders where it appears to be safe and appropriate, and refusing return orders in other situations.
Thank you, Roz. Listen, guys, this has been absolutely fascinating and thoroughly enjoyable. I would like to thank our audience for joining today and for staying on. Please do fill in the feedback questionnaire. Let us know what you want to hear about. If there was one particular jurisdiction that you were really interested in, give us that feedback and we'll see what we can do. The panel, Roz, Larry, Gloria, Will, you have been incredible. Thank you so much for your time and trouble today. We really, really appreciate it. If people want to fill in the questionnaire, and also if you want to see more of our podcasts, our webinars, please go to the Owen Mitchell website, where you will see a plethora of information and ideas and help to support you. On the screen now, I hope my colleague is going to put the contact details of our panel today, so that if you want to reach out to anybody, we're happy to connect you if you've got anything in that particular jurisdiction at that time. I have 1 minute left. Thank you so much. Good morning, good evening, good night. Can I ask my panel to stay on for a few minutes, and we will close up this webinar today. Thank you so much.